Wala sanang gira sa Middle East kung hindi nakulong si Tatay Digong. Sabi ni John Fortich, wala sanang nasawing OFW kung si Duterte pa din ang presidente. Yan 14 hours ago. Let Sara lead now. Filipinos are dying in the Middle East tapos inuuna pa rin ang impeachment. Ano naman ginalamang ng Congress sa gira ng Middle East? Hindi man yung trabaho ng Congress.
To begin with, we recognize the endorsers of the fourth impeachment complaint, the Honorable Benny Abante and the Honorable Paulo Ortega, to make their manifestation with respect to their position on its sufficiency in substance.
Madam Chair, may I be allowed to please give an opening?
You may proceed, Honorable Abante.
Madam Chair, distinguished colleagues, at mga kababayan,
nagpapagang mga balita at pagtalakay sa mga isyu ng lipunan. Bullseye! Opinyon, banat at paglalantad sa katotohanan. Bullseye! What you see is what you get. You decide.
Yan ang mga post, Apollo Vihillas post. Wala sanang gira sa Middle East kung hindi nakulong si Tatay Digong. At kung si Tatay Digong daw nila, mga kababayan yung presidente, hanggang ngayon, hindi natuloy yung gira sa Middle East. At walang nasawi sana. Ayan ang mga post nila. Sabi ni John Fortich, wala sanang nasawing OFW kung si Duterte pa din ang presidente. Sabi ni Susan Loresto Peras, malala na talaga ang mga DDS. Nag-react si Atty. Carlo Ibanez. Sabi ni Atty. Carlo Ibanez, ito na naman ang bagong script nila ngayon. Walang masasawing OFW kung si Digong pa ang presidente. May naniniwala pa din mga kababayan dito sa mga DDS kahit ang mga pananaw nila ay sablay. Ibig bang sabihin, kung presidente si Digong, walang OFW yung nasawi doon, masasalag ba yung mga bomba, yung mga missiles ng Iran kung si Digong ang presidente? Anong gagawin niya? Nakakatawa. At mga baliw lang ang maniniwala sa ganung mga pananaw. Sandali lang, sabi ni Atty. Carlo Ibanez. Ano ba ang capacity ng isang Pangulo ng Pilipinas para pigilan ang missiles ng Iran, US or Israel? May anti-missile shield ba tayo na kayang umabot sa Middle East? May veto power ba ang Malacanang sa foreign policy ng ibang sovereign states? At pwedeng sabihin ng Pangulo ng Pilipinas, kung si Digong pa yung Pangulo, pwedeng pagsabihan si Trump at si Netanyahu, tigilan ninyo ang paglusob sa Iran. Kaya ba yun ni Digong? Hindi nga po napigil ni Digong, mga kababayan, yung pag-arrest sa kanya ni General Torre. Mga kababayan, kung si General Torre lang nag-serve ng warrant of arrest mula sa ICC through Interpol, lagi natin linawin, through Interpol, na may obligasyon tayo, mga kababayan, kung yun hindi napigil ni Digong. Yung missiles pa ng Iran, mga kababayan, at ito pa ang mas ironic. Hindi ba Vice President si Inday ngayon? Siya ang second highest official of the land. Kung totoo na may magic formula ang mga Duterte, bakit hindi niya gamitin ngayon? Bakit wala siyang ginagawa? Kaya pala nila i-save ang mga OFW natin. Wala namang concrete action na pinapakita, sabi po ni Atty. Ibanez. So yung statement na yan, admission na walang ginagawa si Sara in the middle of a crisis. Worse pa, dahil kung totoo nga na may capacity ang mga Duterte na iligtas ang mga OFW, hindi niya ginamit ang powers na yon. It shows na wala siyang pakialam sa mga kababayan natin. Pinatulad talaga ko ni Atty. Ibanez. Kung may kapangyarihan pala, bakit hindi ginamit? At kung wala, bakit nagsisinungaling at pinapalabas na mayroon? Kasi nga po, ang pinapaniwalaan nila na tagapagligtas, si Kibuloy, yung may-ari ng universe, na nagkiklaim, mga kababayan, na kaya niyang patigilin yung lindol. Pero hindi niya napigilan yung pag-arrest sa kanya ni General Torre. Tama po, mga kababayan. Tapos biglang bumanat si Harry Roque. Ito yung post ni Harry Roque. Yan 14 hours ago. Let Sara lead now. So kahit ano po mga pangyayari sa mundo, ginagamit nila para lang, mga kababayan, isulong yung kanilang personal agenda. na makatake over si Sara Duterte bilang presidente. Ang sabi ng supporter ni Digong, Tatay Digong, sabi ni Juliana Page, kung si PRD siguro ang presidente ngayon, hindi siguro tayo kakabahan sa mga OFW na nasa ibang bansa sa mga ganitong sitwasyon, no? Kasi alam natin na may safety measures ang mga ito dahil mahal na mahal niya mga OFW sa mga ganitong pangyayari. Naghahanap na siya ng solusyon. Paano maging ligtas sa mga kababayan na nasa ibang bansa? Kung kaya't isa ito sa dahilan kung bakit halos lahat ng OFW mahal na mahal siya at marami ang nalulungkot o napaiyak sa nangyari sa kanya. Lumaban ka lang, Tay. Maraming naghihintay sa iyong pag-uwi dito sa Pinas. So ito pa, yung isa pang DDS congressman, si Kiko Barsaga. Biglang nag-react na naman po. Filipinos are dying in the Middle East tapos inuuna pa rin ang impeachment. Ano naman ginalamang ng Congress sa gira ng Middle East? Hindi man yung trabaho ng Congress mag-ialam doon sa gira. Ang trabaho ng Congress, legislation, at ngayon may pending impeachment complaint, talakayin. Yon ang trabaho nila. At yung pagtulong doon sa Middle East, trabaho ng executive ng ating Pangulong Bongbong, at may ginagawa na mga contingency plans. Hindi lang makagalaw ngayon, pero in place yung mga contingency plans kasi nagliliparan yung mga missiles ng Iran at mga warplanes ng Amerika. May tatlong eroplano ng Amerika na dali na shoot down ng friendly fire galing sa Kuwait. Kung eroplano nga ng Amerika nadali, na aksidente pa, yung eroplano pa ng Pilipinas para mag-rescue, mag-evacuate close at airspace ng Middle East. Walang pinapaintulutan na lumipad other than yung mga warplanes. Naintindihan ninyong mga DDS. Talaga itong mga taong ito. House of Representatives 20th Congress Committee on Justice. So ngayon, dito muna tayo sa naging discussion kahapon. Yung mga puntos ng mga congressmen in relation doon sa conditional threat, mga kababayan. One of the articles of impeachment, yung pananakot, pagbabanta ni Sara Duterte laban sa ating Pangulong Bongbong at saka ni First Lady, sa ating First Lady, saka kay Martin Romualdez. So ito yung mga puntos, mga kababayan. Panoorin natin yung discussion dito sa Committee on Justice determining the sufficiency in substance.
Very, very short manifestation regarding the video. The whole nation is aware of this video actually, Madam Chair. It came out during a press conference that the Vice President called for when Attorney Zulaika was in detention in the House of Representatives. My take on that, Madam Chair, is you can argue on whether a crime is being consummated or not, because some say that it has not been fully implemented, and so therefore the crime is not committed itself. To me, Madam Chair, I know how a layman would understand that is, it does not take one particular threat to be consummated, meaning to be implemented, for it to constitute a betrayal of public trust. The mere fact, Madam Chair, that it was uttered
Si
by a
Alonso Adjong
sitting
siya,
Vice
mga
President
kababayan.
to threaten a sitting president and claim that she had contracted an assassin to do her bidding is in itself an impeachable act.
Correct.
It's in itself a betrayal of public trust, Madam Chair. So whether or not it was said in jest, whether or not there was an intention, because it's conditional according to some,
He's a Muslim.
whether there was not really an intention, except for example that she herself was killed. So that's irrelevant to me, Madam Chair.
Congressman from Mindanao.
Because the fact that it was said, the threat was said by an official who needs to uphold a high standard of the demand of her office, should be upheld in such a high standard
Correct.
would to me fall under the category of a betrayal of public trust. That is my humble submission, Mr. Chair, Madam Chair, on the issue of the video that just flashed, it's played on the monitor, Madam Chair, Your Honors. Thank you. Maraming salamat po.
Thank you, Honorable Adjong.
O ito si
At this
Digamo,
juncture, we recognize the Honorable Digamo.
na yung asawa niya, si Governor
Madam
Digamo,
Chair,
pinatay
I would
after
like
sa
to
mga
speak
sunod-sunod
from
na
a
threats
personal experience.
sa kanyang
My
buhay.
husband, the late Governor Digamo, before he was murdered. By the way, we will be remembering his 3rd death anniversary tomorrow. That's March 4. He received threats before he was tragically murdered. The threats at first were conditional. Like, if you do this, something will happen. But then, even though they were conditional, the fear and intimidation they caused were very real. Conditional threats can turn into actual harm.
Correct.
Nangyari po yun sa amin. In the same way, when the VP reportedly made statements implying harm to the President, the First Lady, and the former Speaker, those statements are serious, even if phrased as conditional. Kasi words from someone in her position carry weight. It can intimidate other officials, it can influence decision, and even undermine public trust.
Correct.
That is why, in impeachment terms, such conditional threats are considered sufficient in substance. It's not just the wording that matters. It's the effect and potential for harm, especially when the speaker holds high office. Just as in my family's experience, conditional threats really must be taken seriously. Gusto ko lang pong idagdag. The legal connection there talks about a threat does not have to be absolute or immediate to be serious. What matters is its potential impact, especially if the speaker holds power. Conditional threats can intimidate or coerce. Even a statement that starts with "if" can pressure officials or institutions to act a certain way. And high office makes it more serious. Maybe words from ordinary people may be limited in effect, but threats from a person who is holding a national leadership post carry far-reaching consequences. Kaya nga po, public office demands higher standards of behavior.
Correct.
Yun yung nire-require sa atin. Dahil if wrongly handled, and I must admit, my husband must have wrongly handled the situation back then that resulted now to his 3rd year anniversary, still waiting for justice to be served. Yan lang po, Madam Chair. Thank you.
Thank you, Honorable Digamo. Next in line is Madam Endorser. Can we finish first the manifestations of the Justice members before we go back to you?
Yes, Madam Chair.
The Honorable Chua.
Thank you, Madam Chair. Madam Chair, let me borrow the words of the late Justice Cruz, Justice Isagani Cruz, when he defined impeachment as a method of national inquest into the conduct of public men. Ang ibig sabihin po nito, ang tinitignan po dito ay yung mga taong nasa taas ng lipunan kung paano nila maglabas ng behavior sa publiko. Ang hinuhusgahan po dito sa impeachment ay yung kanila pong conduct. Obviously, napanood po natin, hindi po ito yung conduct na inaasahan po natin sa isang tao na may pangalawa sa pinakamataas na posisyon sa ating lipunan. Yung video po, ang tinatawag po natin, res ipsa loquitur. The video speaks for itself. Hindi na po natin kailangan magpahaba. Hindi po ito usapin ng kriminal para tignan po natin ang elemento ng threat. Ang tinitignan po dito po sa pinakita sa atin. Yung conduct ba na pinakita niya ay binetray niya yung public trust? Ito ba yung conduct na inaasahan natin sa isang tao na mataas ang katungkulan sa lipunan? Pag sinagot po ninyo ko na ito po yung conduct, maaari ko pong sabihin na wala nga po talagang substance. That's all, Madam Chair.
Let us be reminded that in various discussions of impeachment process, we try to determine the fitness of the public official to hold public office.
Correct. Lalo na mental
That is
fitness.
for the record.
Dapat
Any
matino
other
ang
member
isip.
who wish to manifest? You
Hindi
would like to
baliw.
add, Honorable Digamo.
Yes, Madam Chair. And if I may add,
Hindi
itong grounds
violent
po na
dapat
ito, we are
ang
not
isang
just
leader.
dealing here with the VP. No? Ang ibig ko pong sabihin, kahit sino po, pwede naman pong ang source of threat is the President. Source of threat could be the Speaker, directed to the VP, the President, directed to the VP. Pwedeng it could be directed to any other public official. Pero yun po yung nakikita natin na hindi talaga dapat binabaliwala para wag naman pong matulad sa amin. So it's not about personalities. It is about the actuations na ginawa at dapat may managot. Thank you po.
Thank you. Next is the Honorable Vice Chair Dumogan.
Thank you, Madam Chair. I don't like to repeat what had already been said, but looking at the allegations in ground number 4, including the video that we had just watched, at this stage of determining sufficiency in form, it has already complied. Thank you, Madam Chair.
Thank you, Honorable Dumogan. We will now go back to the endorser of the impeachment complaint, the Honorable De Lima.
Thank you, Madam Chair. To just be brief, yes, res ipsa loquitur. The video says it all. Res ipsa, the thing, speaks for itself. The video itself speak for what we are alleging as impeachable offenses. No joke, no joke. Then there's no issue anymore as to whether it was meant to be a joke, because it's the VP herself who says, no joke, no joke. So wala na pong question dyan. Hindi na po natin kailangan i-prove na yun ay joke because it came from her,
But it is not a joke.
her own language, admission against interest. There is also no such thing as conditional threat. A threat is a threat, irrespective of whether or not there is such a condition, katulad nung binanggit ng VP, na kung mamatay daw siya, it doesn't erase the fact that she made a threat.
Correct.
So, there is no such thing as conditional threat. It's also a issue. Now, you saw also the video. It has been widely covered even by foreign media. What other country, or is there any other country where we have seen such an incident of the second highest official of the land, a very high official of the land, making such a very open and public and brazen act of threatening the president and the two others? So, malinaw po itong ground na ito. Isa po ito sa tingin ko ang pinaka-malakas na magiging basis ng impeachment. Thank you.
That concludes our deliberation on the fourth impeachment complaint. We shall now proceed to the fifth ground of the third impeachment complaint. Please allow the chair to read. Vice President Duterte committed culpable violation of the Constitution and betrayed public trust in amassing unexplained wealth and failing to disclose all her properties and interest in her SALN in violation of Section 17, Article 11 of the 1987 Philippine Constitution.
So,
We humbly ask for your divine guidance. Grant us clarity of
simula
mind
na yung
that we may carefully discern the issues before us. Grant us integrity of heart that we may be
Dali
guided
lang po.
not by personal interest, political consideration, or public pressure,
nananalangin pa.
but by truth, fairness, and fidelity to the Constitution. Grant us courage to decide according to our conscience, the law, even when the path is difficult. Remind us that the task today is not to judge guilt or innocence, but to determine whether the allegations, if taken as true,
So,
are sufficient
dinidetermine
in
pa
substance
kung
under the
sufficient
Constitution
in
and the
ano.
rules of the House. Help us to remain faithful to this limited but crucial responsibility.
Dali lang po.
May our deliberations be marked by respect. Respect for one another as colleagues, respect for the institutions we serve, and respect for the Filipino people who look to this committee to uphold justice without fear or favor. In a world troubled by division, conflict, and war, we also lift up to you nations suffering from violence and unrest. We pray for peace in lands torn by conflict, for the protection of innocent lives, and for leaders everywhere to choose dialogue over destruction. Let justice and mercy meet, and may peace prevail among nations. Lord, bless this committee with wisdom that builds trust in our democratic institutions. May our actions strengthen, not weaken the rule of law. May everything we do today be done in a spirit of humility and service. All these we ask in your holy name. Amen.
You may all sit down. The meeting of the Committee on Justice sufficient in substance to warrant further proceedings. If the accusation questions about public funds, abuse of authority, and violations of public trust, then we must not close the door prematurely. So today, we turn to the fourth impeachment complaint, endorsed by Representative Benny Abante and D.S. Paulo Ortega. Some allegations may overlap with the third impeachment complaint. Others may reinforce it. Our task remains the same. Determine whether it meets the constitutional threshold of sufficiency in substance. So we ask, is the fourth impeachment complaint consisting of 7 grounds or 7 articles sufficient in substance? Do the allegations rise to the level of impeachable offenses? Do these complaints meet the constitutional threshold to move forward? And importantly, are the allegations credible enough to justify moving forward with the process? Iyan ang tungkulin natin ngayon. And by the end of our deliberations today, it is my hope that this committee will consider all the arguments from day 1 until today, from March 2 until March 4, and be prepared to vote on the sufficiency in substance of both the third and the fourth impeachment complaints. This is not about personalities. This is not about political convenience. Hindi ito laban ng kampo. Ito ay usapin ng konstitusyon. History will not ask whether this was comfortable. History will ask whether we were faithful to our oath. Kung sapat ang reklamo para umusad ang proseso, dapat natin itong ituloy. If the constitutional threshold is met, we should not be afraid to let the constitutional process move forward. Now, let us proceed, calm but firm, fair but fearless. Maraming salamat po. At this juncture, we direct our committee secretary to acknowledge the presence of the justice members, including the ex-officio members, including those who were deputized. Comsec, please.
Thank you, Your Honor. We would like to acknowledge the members of the Committee on Justice, Honorable Attorney Jervil Jinky Beatrix R. Luistro, Honorable Jennifer A. Lagbas, Honorable Brian Poe, Honorable Jonathan Keith P. Flores, Honorable Isabel Maria J. Zamora, Honorable Franz Vincent F. Legaspi, Honorable Loreto S. Amante, Honorable Joel R. Chua, Honorable Ernesto M. Junicio Jr., Honorable Lordan G. Suwan, Honorable Munir M. Arbison, Honorable Bienvenido M. Abante Jr., Honorable Jude A. Asidre, Honorable Rufus P. Rodriguez, Honorable Ramon Rodrigo L. Gutierrez, Honorable John Attorney J.P. Padiernos, Honorable Rene Luis M. Ko, Honorable Janet L. Garin, Honorable Francisco Paulo P. Ortega, Honorable Christopher Shin P. Gonzalez as Deputized Representative of Honorable Ronaldo V. Puno, Honorable Beverly Rose A. Di Macuha, Deputized Representative of Honorable Virginel G. Byron, M.D., Honorable Raymond Democrito C. Mendoza, Honorable Ryan S. Recto, Deputized Representative of Honorable Yevgeny Vincente B. Emano, Honorable Lawrence R. Defensor, Honorable Julian Jam L. Baronda, Honorable Marlene L. Primicias Agabas, Honorable Zia Alonto Adjong, Deputized Representative of Honorable Patrick Michael D. Vargas, Honorable Ana Victoria Veloso Tuazon, Honorable Jose Bong J. Teves Jr., Honorable Munir N. Arbison Jr., Honorable J.C. M. Abalos, Deputized Representative of Honorable Marcelino C. Libanan, Honorable Percival Percy Sendanya, Honorable Antonio L. Pino, and Honorable Walfredo Arman R.D. Maguila Jr., Deputized Representative of Honorable Maria Carmen S. Zamora. That's all, Your Honor.
Before we proceed to the determination of sufficiency in substance of the fourth impeachment complaint, that is Cabrera impeachment complaint endorsed by the Honorable Abante and Honorable Ortega, we recognize the Honorable Bel Zamora.
Thank you, Madam Chair. This is for the information of everyone. We are discussing or deliberating on the sufficiency and substance of the fourth impeachment complaint. As such, I remind you of Rule 3, Section 5, Determination of Sufficiency and Substance. It states here that the requirement of substance is met if there is a recital of facts constituting the offense charged and determinative of the jurisdiction of the committee. What we are looking for, Madam Chair and dear members, colleagues, we are looking for overt acts of the respondent that will show the nexus with the impeachable offenses as stated in the Constitution. Kailangan po natin makita o maipakita na ang impeachment complaint ay may overt acts o yung mga ginawa mismo ng respondent. At ito ay may connection o mangangahulugan na ginawa niya ang mga impeachable offenses sa Constitution. Yun lang po, Madam Chair. Thank you.
Before we proceed, we acknowledge the presence of the Honorable Arnan Panaligan from the 1st District of Oriental Mindoro. At this juncture, we open the determination of sufficiency in substance of the fourth impeachment complaint. To begin with, we recognize the endorsers of the fourth impeachment complaint, the Honorable Benny Abante and the Honorable Paulo Ortega, to make their manifestation with respect to their position on its sufficiency in substance.
Madam Chair, may I be allowed to please give an opening?
You may proceed, Honorable Abante.
Madam Chair, distinguished colleagues, at mga kababayan po na nanonood ngayon sa ating live streaming, the Constitution of the Republic of the Philippines begins with a simple but powerful principle. Ito'y inuulit-ulit po natin to. Public office is a public trust. Pero gusto ko na yung dagdagan na hindi lang po ito public trust, kundi isang sacred trust. At hindi natin maikakaila na ito po ibigay ng Panginoon sa atin. Hindi ito yung slogan. Hindi ito dekorasyon sa ating mga dokumento. Ito ang pundasyon ng ating demokrasya. In a democracy, leaders are accountable to the people. In a democracy, no official, no matter how powerful, is above the Constitution. And that is precisely why the Constitution gave Congress the power of impeachment. Because without accountability, democracy becomes something else. Without accountability, a republic begins to resemble a kingdom, where those in power answer to no one. We are not a dictatorship, Madam Chair. We are a democracy where we believe that we must be governed by laws made by Congress. Impeachment exists so that the people, through their representatives, Madam Chair, may ask the most serious question that can be asked of a public official. Are you still worthy of the trust given to you by the Filipino people? That is the question before us today. Let me be very clear. This proceeding is not about personalities. It is not about political factions. And it is certainly not about the political ambitions of someone who will run 2 years from now. It is about her responsibilities to the nation because of the office she occupies today, Madam Chair. It is about whether the serious allegations contained in this complaint deserve the full and sober examination that the Constitution requires. The complaint endorsed before this committee presents several grounds for impeachment. Let me explain them in the simplest terms possible so that every Filipino listening can understand what is at stake. Dahil kailangan malaman ng ating mga kababayan na hindi biro ang mga akusasyon laban sa Vice Presidente. Unang-una, the issue of transparency and unexplained wealth. Our Constitution requires public officials to disclose their assets through their statements of asset, liabilities, and net worth. What we call as SALN. Now, why is this important? Because the Filipino people deserve to know that those who serve them are not secretly enriching themselves. If a public official earns a certain salary, but their wealth grows far beyond what the salary could reasonably explain, then the people have the right to ask questions. This complaint alleges that certain bank accounts, property transactions, and cash holdings were omitted or understated in the Vice President's SALN. It further raises the possibility that her accumulated wealth may be disproportionate to her legitimate income. Now, if these allegations are true, Madam Chair and my colleagues, that is not a mere clerical error. Hindi po ito biro. This is not a joke. That is what the Constitution calls culpable violation, a willful disregard of the duty of transparency. Pangalawa, the alleged misuse of public funds. The complaint cites findings from the Commission on Audit regarding the use of confidential funds under the Office of the Vice President and the Department of Education. Let us put the numbers in perspective, Madam Chair. More than 612 million pesos in confidential funds were placed under the authority of the Vice President across his offices. And one particular transaction has raised serious questions. 125 million pesos allegedly encashed and liquidated within just 11 days in December of 2022. 11 days, Madam Chair. In ordinary life, if someone withdrew that much money and claimed it was all spent in just a few days without clear receipts, without verifiable pays, people would naturally ask, saan po napunta ang pera? According to the complaint, some liquidation documents contain defective receipts, unverifiable pays, and irregular documentation. These are not small accounting errors, Madam Chair. Hindi po ito biro. Again, this is not a joke. When public funds are involved, every peso belongs to the Filipino people, and when hundreds of millions are spent without clear accountability, the public has the right to demand answers. Madam Chair, that is not free money. That is not a money coming from our own personal pockets. That is the money of the Filipino people. Diba? The public money, aking nabanggit kahapon, is also a public trust. Kaya nga ang pangatlo, betrayal of public trust. This is one of the broadest grounds for impeachment in our Constitution. It refers to conduct that may not always fit nearly into criminal statutes but nonetheless shows gross faithlessness to the public trust. And one allegation in this complaint is deeply troubling, Madam Chair and my dear colleagues. The Vice President publicly admitted that she had spoken to someone about killing the President, the First Lady, and the Speaker should something happen to her. Later, it was said that this merely was a joke. But let us be honest, threatening the life of the head of a state is not something that can be brushed aside as humor, particularly if this was even stated by the second holder of the authority of the land. Hindi po ito biro. This is not a joke. This is not what a wife can say to the husband, papatayin kita sa loob ng kwarto. Madam Chair, when the second highest official in the land speaks of assassination, even conditionally, as said by Congresswoman Digamo, it shakes the foundation of public trust because leadership carries weight. Words from high office carry consequences. Tanungin natin ang ating mga kababayan, if you had a neighbor who worked as an employee in a government office and your neighbor posted a video saying he was planning to kill you, hahayaan mo lang ba? Or would you not want to report that person to his superiors and have him held accountable for his actions? Once again, gusto kong sabihin, hindi po ito biro at hindi po ito dapat magiging katawa-tawa sa lahat. This is not a joke. Number 4, allegations of corruption and bribery. The complaint also presents evidence suggesting that public funds may have been distributed through intermediaries, including testimony from individuals who claim to have transported large sums of cash. These are also allegations of payments connected to procurement decisions. Now, whether these claims ultimately prove true is something that must be determined through evidence. But when sworn affidavits, audit findings, and documentary records raise serious questions about how public funds were handled, Congress cannot simply look away. Because the Constitution does not allow us to look away. Precisely why there is Congress in this country. It commands us to act. Now, some may ask, why impeachment? Why not leave this to the courts? The answer is simple, Madam Chair. Because impeachment is sui generis. It is unique. It stands alone. It is a unique constitutional process. Criminal courts determine guilt and punishment, but impeachment answers a different question. Is this official still fit to hold the trust of the Filipino people? That determination belongs to Congress. Ladies and gentlemen, belongs to Congress. Others will say that a previous impeachment complaint was dismissed. That is true. But that decision was based on a procedural technicality involving the one-year bar rule.
Correct.
Not on the merits of the allegation.
Correct.
Complaint presents new evidence, including
Loading. Dali lang po. Sabi ni Jerry Dalagan,
issues involving SALN and unexplained wealth that have never been adjudicated. The Constitution demands that these allegations be examined. And finally, Madam Chair, my dear colleagues, some will say that this process is political. To that, I say, impeachment is indeed political in the sense that it is entrusted to elected representatives. But it is not partisan. It is political in the same way that democracy itself is political, Madam Chair, because it involves the people's right to hold their leaders accountable. Our duty here is simple. It is not to convict, it is not to condemn, but to determine whether these allegations deserve the full process that the Constitution provides. If we refuse even to examine them, we send a dangerous message that powerful officials can evade scrutiny simply by attacking the process. But if we proceed with fairness, sobriety, and respect for due process, we affirm something far more important than any political victory. We affirm that in the Philippines, the Constitution still reigns supreme and that no one, not even the Vice President, is above the law. Why? Because public office is both a public trust and a sacred trust. Uulitin ko po, Madam Chair, hindi po ito biro. This is not a joke. This is a solemn responsibility. And perhaps these words would also issue a warning to some of our colleagues that will make stupid analogies, Mr. Chair. I would not hesitate even to question that. Ito po, seryoso po ito. Gawin nating seryoso ang impeachment complaint na ito. Maraming salamat po, Madam Chair and my dear colleague.
Thank you, Honorable Abante. May we know if the Honorable Ortega wishes to deliver a manifestation as well?
Yes, Madam Chair.
You may proceed.
I would join my co-endorser with a short manifestation. We endorse this complaint out of respect for our Constitution, and we carry this responsibility in the House of Representatives. This is not about declaring anyone guilty. It is our duty, and it is straightforward. For us to examine the facts and determine whether they are enough, and there is enough basis to elevate it. If the evidence supports it, we elevate it. If it does not, we dismiss it. We owe the Filipino people a process that is fair, steady, and faithful to our mandate. Maraming salamat.
Thank you. As pronounced during day 1 of our proceeding, we will be deliberating on a per ground basis, although we will be voting on the basis of the entirety of the complaint. We will now proceed to the deliberation per ground of the 4th impeachment complaint. Please allow the chair to read Article 1. Culpable violation of the Constitution, betrayal of public trust, and other high crimes, citing the following specific offenses: assassination plot, sedition, and subversion of constitutional order. We are now opening the floor for opinions, comments, and manifestations of the Justice members.
Madam Chair.
The Honorable Franz Legaspi.
Madam Chair, just a short manifestation before I make a motion with regard to yesterday's discussions. Madam Chair, just like to manifest similar to my manifestation yesterday with the Honorable Laila de Lima's own complaint. that we confine, or rather I address this to the committee members, that we confine our discussions to the facts recited. I would also like to manifest, based on my observations yesterday, that we uphold the respect, the dignity, and decorum that this committee deserves, that our chamber is expected to have. The nation is watching us, and I still ideally believe that as public officials or even law practitioners, that people will look up to our characters as examples to look up to, and how we will act today, how we will treat others and speak about others will ultimately shape the values of our people, especially to my fellow youth in the years to come. With this, I wish to reiterate that we confine our manifestations to relevant statements, that we maintain our discussions to the facts recited, and have a fruitful, respectful, and dignified discussion ahead. With this, I move that the discussions yesterday, as they are similar to the impeachment complaint today, be adopted as well for the Cabrera impeachment complaint, as the grounds in both complaints are very similar. Thank you, Madam Chair.
There is a motion to adopt the discussion yesterday on the sufficiency in substance of the third impeachment complaint. In our today's deliberation, in the sufficiency in substance of the fourth impeachment complaint with respect to similar grounds appearing in the two impeachment complaints. Do I hear a second? The same has been seconded. Is there any objection? Hearing none, the motion is hereby approved. The discussions yesterday in the sufficiency in substance of the third impeachment complaint is adopted for the purpose of the determination of sufficiency in substance of the fourth impeachment complaint. May we know if there are Justice members who wish to comment or manifest on the first ground.
Madam Chair,
The Honorable Zamora.
let me just point out the specific paragraphs in the fourth impeachment complaint that refer to the impeachable offense charge. We find the acts under paragraphs 85 to 111, and these are all about the assassination plot. For the record, Madam Chair, thank you very much.
Before we proceed, we would like to acknowledge the presence of the Honorable Deputy Speaker Jefferson Conghun, the Honorable Deputy Minority Leader Jesus Manuel Bong Suntay, the Honorable Deputy
Yung
Majority
bastos
Leader
na
Eliza
congressman si
Micaela
Suntay.
Mica M. Gonzalez,
Nandyan
the
na.
Honorable Deputy Minority Leader Stephen James Titan, the Honorable Congressman Jose Joboy S. Aquino II from the Lone District of the City of Butuan. We likewise acknowledge the Honorable Deputy Majority Leader Vincenzo Renato Luigi R. Villafuerte. We acknowledge as well the Honorable Deputy Minority Leader Reynolds Michael Titan. We acknowledge as well the Honorable Congressman Robert Nazal from BH Party List. We acknowledge also the Honorable Deputy Majority Leader Maria Alana Samantha T. Santos. We acknowledge as well the Honorable Congressman Vincenzo Renato Luigi Villafuerte, acknowledged already. We also acknowledge the Honorable Deputy Majority Leader Gil Cabarangay A. Acosta Jr. And finally, we acknowledge the presence of the Honorable Terry L. Ridon from the Bicol Saro Party List. We acknowledge also the Honorable Deputy Speaker Yaser Alonto Balindong. And finally, we acknowledge the presence
Acknowledgement muna ng
of
present
Senior
ng mga na-late na mga congressmen. Gusto ko munang i-share itong breaking news, mga kababayan, sa inyo. Sabi dito, Vice President Sara Duterte dumating na sa Taguig kasama si Attorney Paulo Panelo Jr. para magsampa ng reklamo laban kay Ramil Madriaga, yung dating aide, mga kababayan na nag-execute ng affidavit. Remember, si Ramil Madriaga. So, magsasampa ng reklamo. Yung affidavit niya, ni Ramil Madriaga, mga kababayan, party siya sa naging impeachment case, gagamitin sa impeachment case laban kay Sara Duterte. Dito po sinama siya sa fourth impeachment complaint as sa file ng mga nag-file ng reklamo sa fourth impeachment, mga kababayan, endorsed by Congressman Benny Abante sa ni Paulo Ortega.
An assassin to kill the president,
Balikan natin.
first lady, and the former speaker of the House of Representatives. Second, what are the recital facts that constitute culpable violation of the Constitution, betrayal of public trust, and other high crimes? The complaint contains an allegation that VP Duterte, during a live press conference which was showed yesterday, Madam Chair, publicly declared that she had already asked a person to take revenge, and that if I get killed, patayin mo si BBM, si Liza Araneta, at si former Speaker Martin Romualdez. No joke and no joke. Thank you, Madam Chair.
Thank you, Honorable Joboy Aquino. Any other member who wishes to manifest on the first ground? If there are no other members, the Honorable Suntay.
Thank you very much, Madam Chair. Kaya ho
So, perjury complaint pala
kahapon
yung final ni Sara laban kay Ramil Madriaga po.
na impeachment complaint. Ang pangunahing allegation ng complaint ay nagsasaad, respondent publicly declared during a live broadcast press conference
Ayan si Suntay, yung bastos na congressman ng Quezon City.
Jr., the First Lady, and the former Speaker,
Supporter ni Sara.
Martin Romualdez, if she is killed. Ito ang ginawang basihan ng Article 1 para sabihing may culpable violation of the Constitution, betrayal of public trust, at other high crimes.
So, ano gali ng mga supporter po, mga politiko at ordinary people, supporter ni Sara, pari-parehas po masasama ang ugali.
May malinaw na problema sa sufficiency in substance. Ang requirement ng rule ay may recital of facts constituting the offense charge. Hindi sapat ang statement na controversial or politically shocking. Sa complaint na ito, ang allegation ay speech lamang. Walang alegasyon na may actual hitman na kinuha. Walang maipakitang may agreement nga o conspiracy na ipatupad dito. Wala rin maipakitang may payment o arrangement na ginawa in order to facilitate such statements. Wala rin maipakitang weapon procurement o alleged overt act. Sa ilalim ng constitutional law, malinaw ang doctrine na kahit incendiary, inflaming, or shocking ang speech, ito ay protected under the freedom of speech. Naipailalim to sa Brandenburg versus Ayo na sinabi ng korte that the speech can only be punished if it is directed to inciting or producing imminent lawless action and likely to incite or produce such action. Ang parehong principle ay kinilala sa Philippine jurisprudence tulad ng Salonga versus Cruz Paño kung saan sinabi ng Supreme Court na kahit radical o disturbing a statement ay hindi punishable kung walang imminent and lawful action. Madaling salita, kahit pa matapang, galit, exaggerated ang political rhetoric, hindi automatic na ito ay krimen. Ang complaint ay umaasa sa interpretasyon ng statement hindi sa factual acts constituting treason, sedition, or conspiracy. There is a Latin maxim, conclusion non probat factum. Ang conclusion ay hindi proof ng fact. Thank you.
The Honorable SDML Noy Defensor.
That's wrong, Madam Chair. We are discussing on the sufficiency and substance and the irrelevant, illogical statements made in defense.
Sinupalpal po,
Has
si
no
Suntay,
point.
irrelevant.
This is a direct threat to the life of the sovereign. And the allegation that the Vice President has contracted an assassin who is prepared to kill the President. It's alleged in both complaints. I have seen the evidence and I have seen all the supporting documents. And this allegation is trial ready. Madam Chair, I move that we proceed to the next allegation.
Madam Chair,
Irrelevant ka, Suntay.
The Honorable, is that a motion, Honorable Defensor?
Yes, it's a motion to proceed to the next allegation.
Correct.
object, Madam Chair.
second.
There
Nag-object
is a
ka.
motion.
Let us give a chance to everyone to speak on each ground. And my good friend, and whom I respect so much, should be minded to withdraw that because precisely there are others who wish to speak. And we cannot stifle any member of the Justice Committee. And our chairman has always allowed everybody to speak until everybody has spoken in this committee. So we appeal to my good friend to withdraw that so that we can
Only
proceed.
because the Honorable Rufus Rodriguez has requested me to withdraw and would gracefully withdraw my motion, Madam Chairman.
That is a statesman. You see, Mr. Chairman, our deputy is a statesman. So
Just for
thank
the
you.
record, the motion to proceed to the next ground has been formally withdrawn.
Thank you, Madam Chair.
All the manifestations of the Justice members are duly noted. At this juncture, we recognize the Honorable Nazal and then Honorable Chua
Thank you.
About me.
and then Honorable Rodriguez.
Third, that is fine.
Good morning, everyone. Thank you, Madam Chair. Consistent with the constitutional threshold articulated under Article 11 and the ultimate facts rule applied during the PBBM proceedings last February 4, 2026. I respectfully submit that Article 1 of the fourth complaint fails the test of sufficiency in substance. The allegations rely principally on public statements characterized as an admission of contracting an assassin. However, even assuming hypothetical admission of the pleaded facts, the complaint does not set forth the essential elements of an indictable offense. There is no identification of an alleged assassin, no pleaded meeting of minds, no overt act towards execution, no defined consideration, and no operational step taken beyond speech. Conspiracy requires implementation elements. Sedition requires overt acts. Culpable violation requires a specific, willful breach of a constitutional duty. None are pleaded with particularity. General invocations of a constitutional order and oath-taking cannot substitute for a clearly
Mga kwan
identified
po ito, kakampi
constitutional
ni Sara.
provision willfully violated. Under the standard consistently applied in the PBBM proceedings, rhetoric, however alarming, does not become an impeachable offense, absent ultimate facts establishing execution. Accordingly, Article 1 rests on inference and conclusion rather than pleaded ultimate facts and is insufficient in substance. I so manifest. Thank you, Madam Chair.
Thank you. Next is the Honorable Chua.
Thank you, Madam Chair. Madam Chair, mukhang nalilito po yung mga kasama natin. Wala po tayo dito para determine yung criminal aspect ng complaint. Nandito po tayo para tignan natin kung pag binasa po natin itong facts, ito po ba papasok as impeachable offense. Now, let me clarify this. Ito pong Article 1, makikita po natin sa paragraph 83 pababa. At dito po, sa paragraph 85, dito po, clearly and expressly, binanggit po dito yung kataga na binanggit po ng ating Vice Presidente. At ano po to? Already as a person to take revenge, and that if I get killed, patayin mo si BBM, si Lisa Araneta, at si Martin Romualdez. No joke, no joke. Now, paano po ito papasok bilang impeachable offense? Sabi po dito sa impeachment complaint, sabi po dito, makikita natin to sa paragraph 91 to 93. Ano po to? Meron daw pong culpable violation ng Constitution. Now, ano po yung specific provision sa ating Constitution ang binayolate? So makikita naman po natin to sa Article 7, Section 5. Dahil dito po, sa Article 7, Section 5, nakasaad po dito ng ating saligang batas, and I quote, Madam Chair, before they enter on the execution of their office, the President, the Vice President, or the Acting President shall take the following oath or affirmation. Ang second paragraph, ito po yung kanilang oath. I do solemnly swear or affirm that I will faithfully and conscientiously fulfill my duties as President or Vice President or Acting President of the Philippines, preserve and defend its Constitution, execute its law, do justice to every man, and consecrate myself to the service of the nation.
Loading, mga kababayan. Sabi ni JK, wake up you stupid people.
Defend its Constitution and execute its laws. Definitely, yung pagbabanta po is not a form of executing its laws. And therefore, there is a clear violation and culpable violation of the Constitution. Second, sinabi po dito at binanggit din po dito sa complaint, betrayal of public trust. At dito po defined under paragraph 94, the Supreme Court has defined betrayal of public trust as a catch-all ground encompassing acts that constitute gross faithlessness against public trust, tyrannical abuse of power, inexcusable negligence of duty, favoritism, and gross exercise of discretionary power to the prejudice of the public interest. Gross faithlessness, pagtataksil sa tiwala ng publiko. Definitely yung pagbabanta po sa ating Papangulo, sa First Lady, at sa ating Speaker ay maliwanag na pagtataksil. Dahil itong tao po, yung Pangulo po natin, ay pinagkatiwalaan at hinalal para mamuno po sa ating bansa. We have to look at the surface. Hindi ko po sinasabi na guilty na. Dahil yung guilty or not, yung trial po yan sa Senado. Ang nandito lamang po ay by mere narration of facts. Sa pagbabasa lamang po ba nito, meron po bang grounds na na-violate? I submit, Madam Chair.
Thank you, Honorable Chua. Before we proceed,
correct.
we acknowledge
Matino
the
itong
presence
mga,
of the Honorable
mga congressmen.
Jose Manuel Tadeo Chel
Yung mga defenders ni Sara ang hindi matino, napakalinaw
We
po.
acknowledge as
Baluktot
well
ang
our
mga
Deputy
pag-iisip.
Speaker, Honorable Raymond Democrito C. Mendoza. And finally, we welcome and acknowledge our Senior Deputy Speaker, the Honorable Ferdinand L. Hernandez, of course, from the 2nd District of South Cotabato. Thank you for coming to all the Kongs. Now we proceed. We acknowledge the Honorable Rodriguez.
Thank you, Madam Chair. Article 1 is based on three grounds for impeachment. First is the culpable violation of the Constitution. Second, betrayal of public trust. And third, other high crimes. To support these three grounds for impeachment, as found in our Constitution, it has three acts that are alleged to support these three, and which are assassination plot, sedition, and subversion. Let us go first to subversion, not as a crime itself, but as a support to the three, either of the three. And so, subversion, Madam Chair, was precisely made illegal in 1937 under Republic Act 1700. However, subversion, like in this case, the state subversion of constitutional order, subversion, Republic Act 1700, was repealed precisely in 1992 during democratic times. In 1992, Republic Act 7636 removes subversion. It cannot be a crime nor a support now to the three grounds that we have. Completely repealed in 1992. The subversion aspect of an act of a Filipino. Then we have sedition, Madam Chair. Sedition is an act of publicly uprising and tumultuously engaging in acts to really remove the established government and officials. So it cannot be because Sara Duterte did not publicly rise with arms to be able to remove the present government. Probably what they want to say is inciting to sedition. Because sedition itself is governed by our Article 139 of the Revised Penal Code, the rising publicly and tumultuously. If you go to Article 142, this will be inciting to sedition, but there is also no recital of facts that the Vice President made speeches or made publications to say, let us remove the present administration. Nothing. In fact, yesterday, if you see the video, she was just present. When her father spoke. Second, when Kiboloy had a mass at a gathering, but she did not speak there. So therefore, against the present government. So these two are out, definitely out. Subversion of constitutional order is no basis to say there is violation of the Constitution, nor sedition or even inciting to sedition. So we now go to assassination plot. Here we go. This is what is cited in the first paragraph on factual allegations is under page 28, paragraph 85. Ito na. Already as a person to take revenge, and that if I get killed, patayin mo si BBM, Lisa Raneta, at si Martin Romualdez. No joke. Now, we have to distinguish, Madam Chair, between conditional threat and threat with a condition. This is defined by the Supreme Court. What is a conditional threat and what is threat with a condition? Example of a second one. Threat with a condition. I will kill you if you give me 1 million pesos. That is a threat with a condition. There's still liability. However, conditional threat, like I'll kill you if I am killed, that is a threat from the grave, so-called. Even, Madam Chair, even the late presidential legal advisor, the late Juan Ponce Enrile, I saw him in an interview. He said there's no crime because it is conditional. The entire, statement about killing somebody only arises if you are dead, and both of them are very much alive. However, this is now the situation. The one who said it is the Vice President. The persons where the conditional threat is being mentioned is the President, the First Lady,
and the Speaker. And so this committee will have to therefore decide whether that reaches the sufficiency of form and substance. Thank you, Madam Chair.
Madam Chair.
The Honorable Zamora.
Madam Chair, I'd like to make another manifestation regarding Article 1. Article 1 of the fourth impeachment complaint. I was part of the prosecution team in the last impeachment, and I handled this. And we saw the evidence of the NBI. In fact, for the information of everyone, this went to the NBI. The NBI filed a case, and they have the evidence. Now, that threats were conditional, is inconsequential. We heard what the Honorable Janice Degamo said yesterday. And I believe that, well, we were all touched and maybe disturbed by what she said yesterday. She said that their family received threats, conditional at the start, but in the end, the threats became real and her husband was murdered. The video that we are talking about was viewed by everyone, including international media, international persons. This happened on the 23rd of November 2024, early morning. And we all saw how the Vice President hurled expletives and publicly admitted that she had set into motion a clear plot to assassinate the President, the First Lady, and the former Speaker of the House. These acts, Madam Chair, are stated, as I said earlier, in paragraphs 85 to 111 of the impeachment complaint. It is clear that the overt acts that we are looking for are in the impeachment complaint. The video that we are all talking about was mentioned in the annexes, or was it? Yes, it was mentioned in the annexes of the complaint. And for everyone's information, this is what we call res ipsa loquitur, or the thing speaks for itself. Everyone heard what the Vice President said, and again, these are mentioned in the impeachment complaint. So we do not go into the elements of the different crimes of the revised penal code, but the mere act, Madam Chair, that she said these words and that she contracted an assassin is impeachable in itself. That's all, Madam Chair. Thank you very much.
Thank you. Any other member who wishes to manifest?
Madam Chair, can I be allowed to speak?
This will be your winding up as well, the Honorable Abante.
Yes.
After this, we will be proceeding to the second round. The Honorable Abante is recognized.
Upon hearing the statement of Congressman Rufus, medyo umiikot po yung aking isipan tungkol dito. Nakalagay naman sa impeachment complaint natin yung bang grossly inconsistent with the dignity of her office. Now, the question is, proper dignity ba yung statement ni Vice President Sara?
Correct.
When it comes to assassination threat.
Correct.
Na hindi lamang assassination threat, Madam Chair, assassination plot.
Correct.
Meron na po siyang
Ginawa nila yung mali na
na
tama.
assassin. Sinabi niya sinabi niya, hindi joke yan. Pangalawa, yung po sinasabi nating gross exercise of discretionary powers. Yung pa'y kasama pa sa tinatawag na discretionary powers ng Vice President to threaten the President. Hindi na pinag-uusapan dito yung sedition. Saka yung subversion. Ang pinag-uusapan po dito, yung dignity ng office ng Vice President.
Correct.
Yung discretion powers ng Vice President. Yung po ba ang tinatawag natin, dapat ba na ito ay gawin nating baliwala, Madam Chair. So while the VP may claim her remarks were not serious, a high-ranking official threatening the life of the head of the state is a high crime and a threat to national stability. Salamat po.
Thank you. Now we proceed to Article 2 of the fourth impeachment complaint. Please allow the chair to read. Betrayal of public trust and graft and corruption. Among the offenses cited are misuse and malversation of confidential funds, violation of Joint Memorandum Circular number 2015-01, COA findings, and falsification of documents. Now we elicit the comment and manifestation of the justice members.
Madam Chair,
The Honorable Rodriguez.
Bongsunta is not here, so I just go ahead. Because he would have been first always. Madam Chair, on Article 2, it is betrayal of public trust and graft and corruption. I would just like to take exception in accordance with what I stated yesterday. Page 34 includes the DepEd. And as I have stated, and I remind again members of the Committee on Justice, that we have no jurisdiction over actuations of the former Secretary of the Department of Education. So, page 934, we say that the statement of corruption by grossly abusing discretionary authority over confidential funds appropriated to the OBP, that's fine. But the statement that DepEd is totally out of the jurisdiction of this committee, the actuations of the former secretary. Then on page, Madam Chair, on page 36, once again, 1223.3 paragraph, 125 million in DepEd confidential funds in the late 2022-2023. Again, DepEd, we cannot have jurisdiction over DepEd. The case of Duterte versus House of Representatives clearly state that the impeachable offenses must relate to the acts of the position and the office where the person is sought to be impeached. And we're not going to impeach the secretary of a department here, but there is an allegation against her as the vice president. So that is page 36. And then on page 38, we have here 129 paragraph. It says a random sampling of receipts and acknowledgement receipts submitted by the OBP and DepEd revealed numerous defects. So once again, the statement of DepEd, the statement about DepEd is that it is beyond our jurisdiction. And then also 132, several receipts, OBP and DepEd should not be included. Now, on page 39, there is this allegation of physical distribution and third-party deliveries, use of DepEd vehicles and personnel. Again, this is about DepEd. It could not be part of our investigation on the allegations of the impeachment. And so, Madam Chair, those are my observation on Article 2. Thank you very much.
Meanwhile, the chair wishes to remind the justice members, while we value the significance of all your arguments, we resolve already to adopt the discussion we had yesterday in the determination of sufficiency in substance of the third impeachment complaint for the purpose of our deliberation on the sufficiency in substance of the fourth impeachment complaint. We therefore encourage the members to raise new matters. Members who wish to manifest, the Honorable Chua and then
Madam Chair.
Honorable Tino,
Madam Chair.
Honorable Joboy Aquino and Honorable Chel
Madam
Jokno
Chair.
and Honorable Abante.
Madam Chair.
and Honorable Nazal. Honorable Chua first.
Thank you, Madam Chair. Madam Chair, as already manifested yesterday, I stand with my position that the Vice President, we should not distinguish between her position as Secretary of DepEd and Vice President by, again, citing the constitutional provision that under the Constitution, the Vice President may be appointed as member of the Cabinet and such appointment requires no confirmation. So meaning to say that the appointment of the Vice President as Secretary of DepEd is concurrent position. Hindi po siya ma-appoint doon if she were not the Vice President. And secondly, siya nga lang po ang nag-iisang Vice President, siya nga lang po nag-iisang Cabinet Secretary na hindi na kailangan ng confirmation.
Correct.
Precisely dahil siya po ay Vice President.
Correct.
And thirdly, in addition to those statements and for the information of the body, the Vice President as Secretary of the DepEd is not receiving any allowance or emolument as Secretary of DepEd.
Correct.
Therefore, and it is very obvious na kaya po siya nandoon, again, because of her position as Vice President.
Correct.
Having said that, Madam Chair, I would like also to point out that from the perusal of the second argument, sabi po dito, ito pong second ground anchored on the allegation that the Vice President has committed betrayal of public trust and graft and corruption. Now, paano po pumasok ito? Kung babasahin po natin doon sa paragraph 1, 2, 3, sabi po dito, on 20 December 2022, Land Bank check number 2244027 in the amount of 125 million was issued to the OVP and in cash at the Land Bank Show Boulevard by SDO Gina Acosta. So dito po sa paragraph na to, makikita natin, wala pa pong participation ng ating Vice President. Now, ito pong paragraph 1, 2, 3, this should be read in relation to paragraph 1, 3, 4. Dito po sa Madriaga affidavit, chain of custody. Dahil ito pong winidraw dito sa paragraph 1, 2, 3 na 125 million na in-encash na sinasabi na nilagay po sa mga multiple bags na nakalagay sa paragraph 125 na binigay po kay Dante La Chica ay binigay po kay Madriaga. At dito naman po si Madriaga, sinasabi po niya na ito daw duffel bag, 4 na duffel bag na kinuha niya ng cash sa Ultra Pasig City noong December 20, 2022. Take note of the date, Madam Chair. Ibig sabihin, ito rin yung araw kung kailan in-encash yung 125 million. Siya daw ay nag-deliver netong 4 na duffel bag sa various recipient including a mayor in Laguna, an office in Timog, and a vehicle left at the Ombudsman parking compound for retrieval. At this point, wala pa rin pong participation ang ating Vice President. Now, paano po napunta dito? Paano po ito naging impeachable offense? Makikita po natin yan sa paragraph 150. Kasi dito po sa paragraph 150, nakalagay po dito, the OVP SDO's testimony that they were instructed to turn over cash to intermediaries, which is Nolasco to Madriaga,
Corroborating
at the
po si
direction of
Madriaga.
respondent Sara Duterte supports direct liability. So dito po pumapasok yung participation ng respondent.
Kaya nag-file ng perjury
dito
si Sara ngayon.
pumapasok yung grounds which is grave, which is betrayal of public trust and graft and corruption. So with that, pagbabasahin lamang po natin yung facts, makikita po natin na may sufficient in substance. That's all, Madam Chair.
We just want to share to the justice members that the Madriaga affidavit referred to by the Honorable Chua is part of the attachments, I think, of both the third and the fourth impeachment complaint. That's for the guidance of the justice members. Before we proceed, we would like to acknowledge the presence of the Honorable Zia Alonto Adjong from the 1st District of Lanao del Sur. We also acknowledge the presence of Deputy Majority Leader Crispin Diego D. Remulla. And we acknowledge as well the presence of Deputy Speaker David J.J.C. Suarez. To proceed, we would like to recognize the Honorable Joboy Aquino.
Thank you, Madam Chair. Earlier, Madam Chair, we heard that from our good friend, Congressman Rufus Rodriguez, that we cannot, as Education Secretary, we cannot impeach her or because they covered. But all I want to say, Madam Chair, is it is the same person also that is being accused of a crime to commit murder. No? What I'm trying to say, isang tao lang to. Pero ginagawa niya sa OVP, ginagawa niya rin sa
DepEd. Correct.
That's all. Simple lang yan, Madam Chair. Thank you.
Next is the Honorable Tino.
Thank you, Madam Chair. Madam Chair, initially, I raised my hand in order to ask for clarification regarding the relevance of the initial motion that was carried, that the discussions on the third hearing that are relevant to the fourth complaint are carried. No, so you already clarified that indeed they are carried, and therefore we do not need to spend so much time recapitulating the arguments that were already raised yesterday, including this argument of our esteemed Dean of Law and colleague, Dean Rufus, Congressman Rufus. No? So he mentioned again the argument about the Vice President as against the Deputy Secretary. And so, we don't have to go through the debates again. No? And I would just like to say that, once again, my position is that we are not impeaching the Deputy Secretary, which would be absurd, but the Vice President carrying out her function as a member of the cabinet as provided for in the Constitution, no, as Deputy Secretary. So yun po ang ginagawa natin dito, kaya nasa jurisdiction po yan ng komite. Ngayon, regarding the second article in the complaint, I believe that it is sufficient in substance because the allegations here are betrayal of public trust and committing acts of graft and corruption by grossly abusing discretionary authority over confidential funds appropriated to the OVP and DepEd, causing or permitting the fabrication and submission of implausible liquidation documents, directing the physical transfer and distribution of large cash sums outside lawful accounting channels, and by obstructing audit and congressional oversight. So, kompleto po yun, no? Mula sa pag-abuso sa confidential funds hanggang sa pagtatakip ng abusong ito sa pamamagitan ng pagteke ng mga dokumento na sinabmit sa COA at ang pagtutol niya o pagtanggi niya na magpaliwanag sa Kongreso sa paggamit nito. And from paragraphs 121 to 122.3, yun po yung tungkol sa 125 million na naubos in 11 days. Tapos from paragraphs 129 to 133, ito naman po yung tungkol sa fabrication of accomplishment reports. And from paragraphs 138 to 140, ito naman po yung tungkol sa refusal of congressional oversight. So I believe, Madam Chair, sufficient po yung allegation of facts to support betrayal of public trust and graft and corruption. Thank you, Madam Chair.
Thank you, Honorable Tino. Next in line is the Honorable Chel Jokno.
Thank you, Madam Chair. While I continue to respect Congressman Rufus Rodriguez despite his comments about law deans, I have to disagree with his argument. First of all, because if we carry that argument to its logical conclusion, it would mean, for example, that if a vice president were to attend a function as Secretary of Education, where the president was also present, and then let's say, hypothetically, were to brandish a firearm or even discharge it at the president, then does that mean that she cannot be impeached? Second, if we carry that argument, then that would mean that the vice president could easily hide behind that distinction and commit plunder, commit other high crimes as Secretary of Education, and there would be no accountability. So I really must disagree. It's impossible to distinguish those two positions. Thank you, Madam Chair.
For the guidance of the members, the exchange of argument is with respect to the jurisdiction of the Justice Committee with regards to the offenses committed as Secretary of Department of Education as to whether or not they can still be considered as within the jurisdiction of the Justice Committee proceedings with respect to impeachment offenses. Next is the Honorable Benny Abante.
On the issue of, just like what my good friend Congressman Rufus said, the VP Sara as Deputy Secretary is not an impeachable officer, and therefore the House Committee on Justice has no jurisdiction over her. No? Now to me, that would be a clever technical argument. Kaya ako ngayon nag-aaral na ng law. Kaya hindi ako abogado dahil si Congressman Rufus magaling talaga ito. Kaya can you imagine, napupuyat ako sa pag-aaral. But anyway, Madam Chair, ito pong clever technical argument na ito, it intentionally confuses the position held with the person holding it. In the Philippine context, the House Committee on Justice jurisdiction is not determined by the status of the person being charged, not the specific desk they were sitting at when the act occurred. For example, nakita ko rin po yung tinatawag nating single personality doctrine. Ito po ang punto rito. You are not impeaching a secretary. You are impeaching the Vice President for her conduct while in public service. The Vice President does not have any split personality. Sino bang ating tinutukoy dito? Si Mr. Jekyll ba o si Dr. Hyde? Di ba? not a split personality. She is a single impeachable officer. Whether she is performing her duties as the OVP or at DepEd, she remains the Vice President
Correct.
of the Philippines, Madam Chair. You cannot strip away her impeachable status just because she stepped into a cabinet meeting. If she commits graft as DepEd Secretary, tulad po na nabanggit ni Congressman Kiel Jokno, she has committed graft as the Vice President.
Correct.
And that makes her unfit for office.
Correct.
Ito po ang punto. The Constitution identifies betrayal of public trust as a ground for impeachment. It does not say betrayal of public trust only in the performance of the office of the Vice President duties.
Correct.
If she used her position as a high-ranking official to mismanage debt funds or take bribes, she has betrayed the trust the people placed in her as what? As the second highest official of the land.
Correct.
The House has jurisdiction because the person is an impeachable officer. Yun lang po, Madam Chair. Thank you.
Thank you, Honorable Abante. Next is the Honorable Flores.
Thank you, Madam Chair. Madam Chair, gusto ko lang sanang maibalik yung usapin about what the Justice Committee is about to be doing right now. I think the questions on whether she was doing it as Secretary ba or as Vice President should be totally left to the discretion of the Vice President whether or not she wants to use that defense. Dapat pagbigyan na po natin yung Vice President to choose kung gagamitin niya ba to as an issue in her defense or whether to ignore it. Wala po sa atin yan. Ang importante po is ibalik natin ang usapin sa ano ba ang trabaho ng Justice Committee. And our work only, Madam Chair, is to determine whether or not may sufficiency in substance po ba ang allegations that are stated in the impeachment complaint. So whether or not we have jurisdiction as far as her position is concerned, whether as DepEd Secretary or as Vice President, I believe it is siguro our responsibility also to leave it to the Vice President whether to adopt this kind of defense or not. Or even not to answer it at all, Madam Chair.
Thank you.
Madam
The
Chair.
Honorable Redon.
Well, sa totoo lang ho, kahit hindi na ho natin pag-usapan yung split personality between Vice President and DepEd Secretary, siguro maganda pag-usapan na lang ho natin yung usapin po ng tenure. Kasi impeachable officials are impeachable within their tenure of office. No? So the Vice President has a tenure of office from June 30, 2022 to June 30, 2028. So ang tanong po, yung po bang mga impeachable acts, impeachable offenses, kailan po ito nangyari? Nangyari po ba ito within this particular tenure of office ng isang impeachable officer? Kung ang sagot po dyan ay oo, and quite certainly, yung pong acts niya, Vice President, happened during her tenure of office while she was DepEd Secretary, pasok po yun.
Correct.
As impeachable acts.
Palusot lang yun mga defenders ni Sara.
While she
Kalukuhan.
is Vice President. Yun lang po, Madam Chair.
Binabaluktot nila yung
And
batas
of course, we acknowledge, we
para
recognize the
makalusot.
Honorable Defensor.
Thank you, Madam Chairman. Para matapos na din itong usapin tungkol sa depensa na magkahiwalay ang personality nila, we simply have to go back to the enumeration under the Constitution na ang impeachable officers ay the President, the Vice President, the members of the Supreme Court, the members of the Constitutional Commissions, and the Ombudsman without qualification, without exception na nagsasabing unless otherwise they are appointed as DepEd Secretary or DNR Secretary. So that would be clear, and it's the Constitution itself that has laid down that enumeration to establish the jurisdiction of the committee. Maraming salamat, Chair.
Thank you. That concludes our
Madam Chair.
deliberation on the
Madam
second
Chair.
round.
Hindi pa ako natawag na
The Honorable Suntay.
on the alleged misuse of confidential funds. Ginagamit ito ng complainant para ipakita na may misuse o malversation ng confidential funds. Pero mahalagang tandaan na ang paggamit ng confidential funds ay governed ng COA CPM Joint Circular 2015-01. Sa circular na ito, kinikilala na ang confidential funds ay ginagamit para saan? Surveillance activities, intelligence gathering, informant payments. Dahil dito, cash transactions talaga lahat yan. So hindi porket may mga cash transactions o may movement ng funds, ibig sabihin meron ng malversation o merong corruption na nangyayari. Hindi rin pwedeng sabihin bakit nagastos yung pera in 11 days as alleged. Dahil ang spending, yung bilis ng paggastos, hindi naman automatic, ibig sabihin illegal na. Confidential operations often require immediate payments to sources like informants.
Ipaliwanag niya muna si Mary Grace Piatos
Ay hindi nito pinapakita kung saan napunta ang
kung bakit
pera.
yung beneficiary,
May personal
Chichiria,
benefit pa
Suntay.
napunta o nakuha ang Vice Presidente. Wala sa
Diba?
allegations nang tumanggap siya ng bahagi ng pera. Walang nakasabi.
Ipaliwanag niya yung Chichiria kung napauno. Ano nangyari doon?
Ang reliance ng complaint kung babasahin
Puro
natin,
kayo palusot.
mula sa mga COA audit findings. Audit observation memorandum, notice of suspension, notice of disallowance. Pero sa ilalim ng COA audit rules, ano ba yung audit observation memorandum? Preliminary observation lang ito. Ano yung notice of suspension? Pagkulang ang dokumento. Ano yung notice of disallowance? Administrative finding. Pero ito, subject to appeal.
Madam Chair, point of order muna.
There's a point of order. Honorable Suntay, let's hear the point of order of the Honorable Abante.
Yung ba pinag-uusapan natin? Natanong ko, yung ba pinag-uusapan natin?
This is about confidential fund.
Oo.
Yes, this is about confidential funds.
Pinag-uusapan natin kanina,
Madam Chair, this is
Kung
regarding
lang,
confidential
Let's
funds.
Nagpapaliwanag
allow
pa
the
ako.
Honorable Abante to finish the point of order.
ang pinag-uusapan natin kanina, kung yung office ng Secretary of Education, saka yung Vice President's office, impeachable offense ba yun?
Madam Chair,
Pinag-uusapan yun. Dali lang, nagsasalita
Kindly
pa ako.
wait
Hindi
until
ba
he
naman, no?
finishes.
No. Pinapaliwanag
Kulit ni
mo
Suntay.
kung paano ginamit ang confidential funds. Hindi pa naman pinag-uusapan yan eh.
Out of order si Suntay.
Paliwanag ang paliwanag. Dapat yan pinag-uusapan niya sa impeachment court. Hindi dito. Madam Chair, yun lang.
For the guidance of the Honorable Abante, there are allegations as to misuse of confidential fund in the office of the Department of Education with the Vice President as Secretary of Education. So, it is my humble submission that the manifestation of the Honorable Suntay is aligned to the deliberation on the second round of the fourth impeachment complaint. The point of order is overruled.
Thank you very much, Madam
The Honorable
Chair.
Suntay may proceed.
And to my good friend, Congressman Abante, if I may continue.
You may. Thank you.
Hindi ito automatic proof ng graft o malversation. Ito ay consistent sa sinabi ng Supreme Court sa Navales versus People at Gillian versus People. GR numbers 219, 598 at 220108. Kung saan sinabi ng Korte na procedural irregularities on procurement violations do not automatically result in criminal liability or graft. Makikita rin, kagaya ng sinabi ng aking paboritong colleague, Congressman Joel Chua kanina, may nabanggit siya tungkol sa kay Madriaga, affidavit ni Madriaga. Maitanong ko lang, nasaan ba si Madriaga? Diba, nakakulong yata. So we are relying on an affidavit issued by an individual who is currently in prison. Now, sino ba si Madriaga? Meron ba siyang appointment kay BP Sara to prove that he is an employee or an authorized person? Para ma-direct na naman natin yung linkage nung dalawa. Kasi if we rely heavily dun sa affidavit niya, it should not come
Madam
from
Chair,
a polluted source.
point of
Madam
order.
Chair.
There's another point of order. Let's hear the Honorable Dilemma.
Are we talking now here about the credibility of a prospective witness in these proceedings? We're not yet at the evidentiary stage. We're not yet supposed to judge whether or not Mr. Madiarga is credible. So it is premature and it tries to divert the matter now. We're just talking here about the confidential funds and also about the concurrent capacity, of the commission of offenses of the Vice President in her concurrent capacity as Secretary of Education.
Madam
So let's
Chair.
not talk yet about whether or not worthy, whether or not credible, whether or not totoo yung sinasabi ni Madiarga. We have yet to hear from him, aside from this sworn testimony, of a sworn affidavit. So, that's out of order, Madam Chair.
Madam Chair,
The Honorable Santay.
it is necessary to raise this because his affidavit is attached to the complaint and it is relied on heavily. Yun lang po ito.
Nevertheless, the Honorable
But-
Santay, please be reminded that we are only at the stage of the sufficiency in substance. We are not discussing yet the weight of the evidence attached.
Yes, I know, Madam Chair. I
The
just
point
want
of
to make
order
a-
is sustained.
Madam Chair,
Thank you very much, Madam Chair.
Madam Chair, just a quick rebuttal.
The Honorable Chua.
Thank you, Madam Chair. Madam Chair, I agree with the...
The Honorable Chua is reminded to refrain from further commenting to the manifestation which has been the subject matter of the point of order of the Honorable Dilemma.
Thank you, Madam Chair. Madam Chair, this is just a recital of facts. By the reading of the affidavit itself, titignan po natin kung meron nga po talagang offense charge. At maliwanag naman po dito, meron pong perang nilabas, as cited in paragraph 1, in paragraph in paragraph 1, 2, 3 of the complaint. And ito pong 125 million na binabanggit dito, sinabi rin po sa paragraph 125 ay pinasa sa kay certain Dante La Chica. At dito rin po sa paragraph, dito rin po sa complaint na to, maliwanag sa paragraph 134 na sinasabi po ni Madriaga na siya po yung kumuha na itong pera at dineliver niya. So meron pong money trail na hinahanap po tayo. Now, bakit po nakunik ang Vice President? Kasi po, sinasabi rin po dito sa paragraph 150, sinasabi po dito na yung pong pagpapasa ng pera from the SDO to another na wala naman pong connection ay upon the instruction of the Vice President. Now, dito rin po sa ating affidavit, nakalagay rin po dito at dinefine din po dito kung ano po ang definition o element ng graft and corruption. Nakalagay po yan sa paragraph 146. RA number 3019, paragraph 3A, penalizes public officers who persuade, induce, or influence another public officer to perform an act constituting a violation of rules and regulation. Definitely, yung pagpupunta po ng pera from one person other than the SDO is a violation of rules and regulation. Thank you po.
Madam Chair, sir, a quick
Thank you.
reply.
Before I call the Honorable Santay, let me finish first with the list. The Honorable Nasal and then the Honorable Acosta.
Thank you, Madam Chair. Madam Chair, Article 2 likewise fails to meet the constitutional threshold of sufficiency in substance. The issues raised, particularly those concerning confidential funds. Under Joint Circular number 2015-01, audit observation memoranda and notices of disallowance were substantially discussed during prior deliberations. Nung in-apply ng committee yung standards na ito during the PBBM proceedings, Sinabi nun na ang preliminary audit findings are not final adjudications of liability. Audit observation memoranda and notices of disallowance remain appealable and subject to administrative and judicial review. Kaya standing alone, kitang-kita na these do not establish graft malversation or betrayal of public trust. Rapid liquidation by itself is not per se unlawful. Cash handling is intrinsic to the nature of confidential and intelligence funds. What must be pleaded are ultimate facts of unlawful conversion, personal appropriation, manifest bad faith, or a specific amount personally received by the respondent. Pag binasa yung complaint, wala naman naka-allege dito na essential elements. Puro inferences lang ang meron. Inference is not an ultimate fact. For these reasons, Article 2 likewise fails the insufficiency in substance threshold. Thank you, Madam Chair.
Next is the Honorable Acosta.
Madam Chair, while I agree to the Congressman Nazal and Congressman Bong Suntay that COA findings are not criminal judgment, but are highly relevant in this discussion on whether or not pleaded facts in this fourth complaint shows an accountability breach. Our test here today for the members is whether the complaint, the fourth complaint, pleads objective audit red flags, which is the ultimate facts recited, supporting betrayal of public trust and that of graft and corruption, Madam Chair. My second question, Madam Chair, is for the two gentlemen who, Pastor Abante and Congressman Ortega. In their pleading, Madam Chair, one of the evidentiary value is JC number 2015-01, and in relation to that, notice of disallowance addressed to the VP dated August 8, 2024. My question, Madam Chair, is whether or not Annex G2 or that notice of disallowance August 8, 2024 have already attained finality.
Would you like to comment, Honorable Abante? He's asking about the status of the notice of disallowance. I believe this is the 73 million of the Department of Education.
I think, Madam Chair, that the COA would have more of the right to answer that than us, no, because they're the ones that actually gave,
Honorable
the disallowance.
Acosta,
Thank you, Madam Chair.
are you done?
Madam Chair, can I would be able to just answer the manifestation of Congressman Nazal?
Before I call you Honorable Abante, allow the chair to call first the Honorable Suntay.
Thank you. Just a quick reply to the statement made by our good friend, Rep. Joel Chua. Yung nabanggit niyang pera that went to Lexica and passed hands, that shows movement of funds. It is not a proof of illegality of use of personal appropriations of the said funds. In fact, the VP is a high-ranking official, and she relies heavily, and as well as other officials, on her subordinates, accountants, unless it can be shown and can be proved that she personally fabricated the receipts, she received the money, or she had gain from
Doon
those
na yun
funds.
sa trial, Suntay.
I believe that...
Hintayin mo yung trial.
Thank you, Madam Chair.
Talagang itong taong to.
Madam Chair.
Before I bring back to you the floor, Honorable Abante, since you are the endorser, let me finish first the other congs. The Honorable Ridon is recognized.
I think most of the matter has already been discussed yesterday. We're basically just reprosecuting the points that have already been raised yesterday. Even the defenses of Vice President has already been stated yesterday, which is why the endorsers and the other congressmen are also...
Tama na, paulit-ulit man lang. Ayos na yon. Sahin ko na lang yung mga reactions ng mga DDS para masaya naman yung mga DDS, mga kababayan, na ang laging sinasabi yung maleta daw. Ibigay ninyo sa akin yung maleta. Asa na yung maleta ko para bilangin ko live Ngayon, ibigay ko muna sa inyo yung latest na balita tungkol sa file niya ng perjury charge. Mga kababayan, may final siyang perjury charge kay Madriaga. Yan. Gusto niyang i-intimidate mga kababayan si Madriaga kasi kasama yung kanyang affidavit sa fourth impeachment. Sabi dito, Vice President Sara Duterte dumating sa Taguig kasama si Attorney Paulo Panelo Jr., yung anak ni Sal Panelo, para magsampa ng reklamo sa Office of the City Prosecutor Taguig laban kay Ramil Madriaga. O ngayon, nag-react mga kababayan si Attorney Carlo Ibanez. Sabi ni Attorney Carlo Ibanez, yung rockstar vlogger, dumating daw si Vice President Sara Duterte sa Taguig Prosecutor's Office para magsampa ng perjury complaint laban kay Ramil Madriaga. Ang tanong, totoo bang may genuine cause of action or is this a move to intimidate a witness? Malamang gusto lang i-intimidate si Ramil Madriaga. Hindi na yun ma-intimidate kasi nakakulong na. Kapag may isang tao na nagsasalita laban sa isang makapangyarihan sa opisyal ng gobyerno at unang response ng opisyal ang kasuhan siya ng kriminal, ano ang magiging epekto dito sa ibang posibleng witness? Simple lang, matatakot na silang magsalita. Sa batas at sa investigations anya, may tinatawag na tayong chilling effect. Kapag nakita ng ibang tao na ang isang witness ay agad kinasuhan, pagkatapos magsalita, ang mensahe ay malinaw. Ano daw yung mensahe? Hindi na mahalaga kung manalo o matalo ang kaso. Ang malaga ay ang takot na may papadala sa ibang gustong magsalita. Malamang, ito yung mensahe ni Sara Duterte. Yan, sino man po na titestigo laban sa kanya during the impeachment trial, kasi siyempre magpe-present ng mga witnesses. So, matatakot na kasi si Ramil Madriaga nga, kinasuhan niya ng perjury ngayon. So, sabi dito, matatakot na niya yung iba na magsalita. At sa mga corruption investigations, napakadelikado niyan. Dapat ang katotohanan kadalasan lumalabas lang kapag may naglalakas loob na witness. Nilihilihis din ito ang usapan mula sa totoong issue. Ang tanong ng publiko ngayon ay simple lang, totoo ba ang mga aligasyon? Yon ang mga valid questions, mga kababayan. Dapat, mga kababayan, si Sara mag-focus sa kanyang defense in the Senate. Hindi yung i-intimidate yung mga possible witnesses. Kung wala siyang kasalanan, doon niya sagutin sa Senate trial. Di ba? Ganon dapat. Kaya lang parte ito ng mga strategy ng defense na ayaw nila na umabot sa Senate trial tulad ng ginawa po last year ni Sara na technical para hindi na magkaroon ng Senate trial. Kasi ang sabi ng mga observers, mga kababayan, ang kinatatakutan ni Sara, mga kababayan, yung mabuksan yung kanyang mga bank accounts. Matuloy yung impeachment trial at mabuksan yung kanyang mga bank accounts. Pero sabi dito, pero sa halip na sagutin ang substance ng aligasyon, ang nangyayari ngayon ay ang spotlight ay napunta na sa kaso laban sa witness. Ibig sabihin, hindi na pinag-usapan ang accusation. Ang pinag-usapan na ngayon ay yung nagsabi, yung taong nagsabi ng accusation. Sa politika may tawag dyan, shooting the messenger. Pero sa rule of law, mas malaga ang katotohanan kaysa katahimikan. Kung mali ang sinasabi ng witness, napakasimple ng sagot, ebidensya, hindi intimidation. Ayan mga kababayan ang sabi ni Attorney Ibanez. Di ba? Maraming salamat po sa inyong panonood dito sa ating live streaming. Ako po si Dante Maravillas. Bye-bye. God bless. Max Framing and Lifting Cream, pinapahid po sa mga pulses in affected area. Mahinam po sa paninigas ng mga kaso-kasuan. Ito naman po, Automax Radiant Serum. Sa mukha naman yung application, anti-aging po siya. You will look 10 years younger than your age. Sa mga cancer patients naman po, baka lang gusto ninyo itong itry. Nangyari Red Mixed Fruit Drink. Hindi mo po siya gamot, food supplement siya. Kaya lang, gawa siya mga kababayan sa goji berry. Yung goji berry may anti-cancer properties. O ngayon, yung mga inquiries ninyo, dumiritso na lang kayo sa aming messenger sa Facebook para masagot namin agad. Ayos pa? Ayos na ayos niya, Mr. Maravillas. Sa mga nagana po ng malinis and spacious fitness gym, pumunta lang po kayo sa aming Colossal Fitness Gym. May Grab ka rental din po kami. But anyway, ito po pala yung aming bagong product na binibenta online. I am worldwide amazing pure organic barley powdered drink mix from Australia. Negosyo to ng aking anak na architect entrepreneur Riz Maravillas. Ayan po. Kontakin na lang po ninyo siya, Riz Maravillas on Facebook. Ang mga health benefits niya, boost immunity, improves digestion, enhance energy levels, packed with antioxidants, prevent cancer. Ito naman po yung bago naming product na binibenta online. Eye Glow Serum, whitening po siya. Tingnan ninyo yung epekto sa aking anak na architect before and now. Yung mga inquiries po ninyo, dumiretso na lang kayo sa kanyang Facebook account, Riz Maravillas.